Good morning, everyone. Thank you all for joining us for today's session. This is part of the Tech for Success Essential Guidance for SMEs webinar series, which is giving us a weekly opportunity to explore key areas that SMEs are needing to consider as we all adjust to the impact of COVID-19. We are shortly going to be joined by Ben Travers. Ben is a technology lawyer and he leads the intellectual property, IT and data protection team at Stephens Scown. Ben's going to talk to us about how to ensure any short-term digital decisions that we're making right now don't create long-term problems. He's going to look at some of the pitfalls of online trading and how to avoid them. And he's also going to give us some insights into cybersecurity and privacy regulations that we all need to be very aware of. Just a quick reminder about next week's presentation. Alison Lambert from Commissioning HR is going to be looking at the current considerations that HR should be bringing for all of our SMEs at the moment. Now this is going to be on Thursday morning, so please make a note of this. Details will be on your screen any minute now. We also hope to add some additional sessions to this series for the future, and we will let you know more about those through our usual channels. Before we get started, there are just a couple of points I'd like to share with you. So as always, for those of you who've joined us before, you know that my name is Siobhan Lavelle. I'm a specialist in reputation management, crisis and change communications. I am moderating our session today and I'm going to guide everybody through. As always, your microphone is on mute and this helps everyone hear our speakers clearly, but we really do want your questions. This is a great opportunity today to ask for Ben's input on the legal aspects of your technology journey. So please use the Q&A feature in the bottom of your Zoom screen. You can use that to submit your questions as we go through today's content, and I will put those questions to Ben towards the end of our session. As always, we will be sharing a recording of this webinar on YouTube, along with a summary of questions and key points. So please look out for links to that after today's session. And finally, if you're using Twitter today, you can see the event hashtag on your screen. So hello, Ben, and welcome to today's webinar.
Hi, good morning.
Good morning. I'd also like to welcome Julian. Many of you know Julian Wills, who's Managing Director of TimeWade and founder of Technology for Success. Now we can see Ben, but we can't see Julian, but you are there. Hello, Julian.
Hi, yes, no, I'm here.
You're there, good morning.
Hi everyone.
I'd like to ask you both a question before we dive into Ben's details. So you both bring different perspectives to the use of technology. We know that businesses are being innovative and we know that our ways of working could be changing forever. So what are the trends from your perspective that we're seeing as people shift to a more long-term view of this? Julian, perhaps you'd like to answer first.
Yeah, thanks. So I think it's really interesting actually, because what we're starting to see from our customers and the feedback that we're getting from the businesses that we're working with is, whilst initially it was sort of customers going into crisis mode, working out how they could start working remotely, etc., and without outside of the sort of traditional office walls. And there's been a period where I think we've seen a lot of those businesses working, if you will, in the business, and the owners and sort of senior management teams effectively just trying to keep up with the day-to-day. But I think we've certainly over the last week or so really started to see a trend where our customers are starting to actually really believe that the technology works and start to ask questions around, okay, how can we actually make this better? What are the next steps for us to take? How can we sort of build a plan around this? And even to the extent where some customers are really considering whether they actually need an office at all anymore. So I think it's a really interesting time. And Ben, sort of interested to hear your thoughts as well on this.
Yeah, well, I would echo that as well. It's been an interesting few weeks. I think at the beginning, as you say, people were making some very quick decisions, and for obvious reasons, they were very much in survival mode. We're starting to see a couple of things now. We're starting to see some of those ramifications from those decisions coming back as businesses start to get used to this new way of working. we're starting to see some businesses becoming a bit more optimistic about these sort of issues, and seeing that this may not be just survival in the short term, but could have a major impact on their long-term business plans. And that's then causing them to start unpicking some of the decisions that they made earlier. We're also starting to see, I think, a shift in the way consumers are treating the businesses that they're dealing with. And a lot of the things that I'll touch on in the talk are around reputation and building trust with your online consumer base. And I think whilst consumers were probably relatively patient at the early stage of the lockdown, we're starting to see a shift in their expectations now of the way that businesses are going to deal with them and interact with them, which again is forcing this other step change in the way that businesses deal. So really interesting and really quick moving at the moment, these trends.
It's interesting. We've come an awfully long way in the last 7 or 8 weeks, haven't we? So thank you both for sharing your perspective there. That's really insightful. I'd now like to hand over to you, Ben. For everybody listening, Ben is going to take us through some essential tips that are going to help guide our business from a legal perspective as we adopt these new technologies. So thank you, Ben, and over to you.
Great stuff. Thank you very much. Okay, so I put the talk together in a series of tips, and the reason that I've done that is because there are some really simple, practical things that I think businesses can do at this early stage to try and make sure that the change that they're adopting, the digital change they're going through, is sustainable. And I think one of the first things I would say is that there's a tendency very often for businesses to assume that the legal side of things, particularly when it comes to the online world, is about red tape. It's about ticking compliance boxes. Is actually, and I expect you expect me to say this, it goes very much to the heart of the sustainability of a business and its interaction with users. Organizations that do this properly have a really good opportunity to build trust with their user base, and in that create a USP compared to their competition. So that's a theme that I think you'll see runs through a lot of what we talk about today. So the first tip is, and I think we're organically starting to see this anyway, but the first tip is for businesses to stop, take a deep breath before making any decisions, think through the long-term consequences. We've had this stage where businesses are using digital technologies for the first time for, as I said earlier, very valid reasons, but not necessarily thinking through those long-term issues. And the pace at which businesses have been making those decisions is probably the biggest change that we've seen. In our day jobs as a team, we look after businesses that are developing technology or adopting technology, and we've seen projects which might have taken weeks or months or years pushed through in days. We've seen organizations that have had no online sales presence in the course of a week go from nothing to having a website and making sales. And often it's the long-term strategizing that's been the casualty in that quick, swift decision-making process. So first thing, stop, deep breath, think about the longer term. Second thing I wanted to talk about, and again, I am a lawyer, and so I don't need to make any apologies for sounding like one, but sweating the small print is really, really important. It's always been the case that businesses don't view online contracts with the same gravitas, they don't give them the same weight as they do offline contracts. But when an organization signs up to use an online platform, whatever it might be, they are agreeing to the terms and conditions of that platform. And some of those terms and conditions can be quite sticky, particularly when you're looking at free content. So, for example, products like Dropbox, which have terms and conditions which are very clear, don't really fill you with confidence about the confidentiality of the information that you're sharing. And I've done a LinkedIn video on that. People can have a look at it if they want some more detail. Some of the Microsoft platforms require you to give a license to the intellectual property that you share over those platforms. Things which businesses don't necessarily appreciate when they sign up to these services, but which could have a long-term negative impact on those businesses going forward. We saw a similar thing a few years back when Facebook was becoming really, really big, and we had some photography businesses that were, for example, uploading lots of content onto Facebook to show off their portfolio, essentially, but then struggled to make any money out of that portfolio, charging royalty fees for images and so on because of the licenses they'd given through the social media platforms. So it's really important that when you're using those platforms, you check the terms, you treat them as you would any other tool that the business is going to use. It will serve a purpose, it will have a use, but you need to understand how you're going to use it in the right way for the job that you're trying to achieve. And understanding those terms is really important. Understanding the terms and conditions is also not that tricky. Most of the organizations that have these online platforms have terms and conditions written in quite plain English. The disconnect, the problem seems to be that what those terms and conditions say is so far removed from what most businesses expect them to say, is that they sort of shrug their shoulders, shake their heads and say, well, they can't possibly mean that. They can't possibly want to get their hands on my IP. Actually, they do, and it's very transparent about how they're going to do it. So reading those is really important. If you are going to upload content, and I'm thinking particularly of businesses that might be providing some services online at the moment, think also before you do so about all of the blood, sweat and tears that's gone into creating that content. Imagine, for example, a personal training business that's spent some time developing their regimes, or any other form of consultancy business that has their methodologies that they've developed over time. Particularly in the early days of the current situation, we saw businesses who were taking that content, which had a great value, they'd put all sorts of effort into it over the years, and uploading it to platforms where essentially they're losing control of it. I think here the tip is not to discourage people from using those platforms, but link to the earlier point, sweat the small print, check that the platforms that you're using are appropriate for sharing the information that you want to. Check also that you're not giving away any IP licenses, so you're not going to have problems using that intellectual property in the future. Really, really key thing. Stuff that businesses can do, for example, you can include trapped data in content. Trapped data is essentially a mistake in your content. So I know this is painful for many organizations, but thinking about perhaps putting a couple of commas in the wrong place in a document, so that if somebody does right click, copy paste it, you can clearly show that they've copied those errors across as well, and therefore it's an infringement. Making sure that you've got your trademarks in order and your designs in order and all those sorts of things before you disseminate this content through third-party platforms is going to be really, really important. So moving on to another theme, talking there earlier about platform terms and conditions and so on. Moving on now to have a look at cybersecurity risk. We're seeing a bit of a perfect storm at the moment on cybersecurity. We're seeing a 400% increase, according to Action Fraud, in attacks relating to the pandemic. We're seeing employees working from home, which makes them more vulnerable. They can't stand up as they might do in an open plan office, meerkat-like, and ask their neighbor if they've received the same phishing email, or if the communication they've received looks from its tone of voice as if it's been sent by the finance director. Those employees are also more vulnerable because they may well think that they're more likely to be able to get away with things. So employers have an obligation to report cyber attacks and to deal with them in a timely fashion. If an employee working remotely at home thinks that they're not going to get spotted, they might not raise their hand and tell their boss, and that could put the employer in breach. So a training point really here, making sure that employees are aware of the risk, that they know that there's a heightened risk at the moment, that they are trained on the tools they're using. So again, if they're using tools to communicate, that they understand how to use those in a secure fashion. Another element which makes this quite difficult at the moment for businesses is particularly those businesses that are switching to a direct-to-consumer model, or who aren't used to dealing with consumer data. Consumers have a really strong right to protect how their data is used. And so businesses that are using that data, particularly at a time when their staff are perhaps working from home, using online tools that they're not used to, it's a real risky time at the moment. So making sure that that training is up to date is really important. And it does link back to the earlier point about the tools that are used. It links also to communication, and this is communication not just of personal data, but also across teams and so on. So making sure that those communication tools you use are secure are really important. Making sure also that you communicate appropriately for the tools is really key. Lots of the free platforms that people use are not going to be able to guarantee the levels of security that you as an organization want to be able to offer your consumers. If one of those platforms suffers a breach, there's a hack which means that emails are available for sale, for example, the organization that put those email addresses onto that platform could well end up carrying the can when it comes to liability. So understanding those tools, understanding the warranties and the reassurances they're going to give to make sure that they're looking after data, whether it's consumer data or employee data, is really, really important. But also consider a principle of data minimization. Do you need to share all of that data? So for example, you may be discussing a client via a communication tool that you wouldn't normally use. Is it possible to do that without giving away any personal information, without giving away any confidential information? So think through how we're using those tools, and remember that communication through these mediums is not the same as communication face-to-face with a colleague in the office. So communication, but doing it securely, both for your own safety, to avoid the risk of cyber breach, but also from a reputation point of view. Because what we don't want is consumers to suffer a data breach and then to track that back to one of the organizations that they've been dealing with. It links very much to remote working generally. And one of the frustrations that I think we're seeing at the moment as a result of people shifting so quickly is that organizations have spent a lot of time thinking about security. They've spent a lot of time thinking about GDPR, and I'll try not to mention that acronym again because I know that it has a negative reaction for many people. But organizations have spent a lot of time and money getting their house in order for that, and have almost thrown all of that work out of the window with their remote working procedures. And a lot of that, going back to the earlier point, is because of the platforms that they're choosing to use. Not all of it, some of it's cultural, some of it's to do with the training of their employees. But it's a real shame. The ICO, the Information Commissioner's Office, the people that monitor this stuff, see this time that we're going through as a real stress test of organizations' compliance with their obligations on privacy and cybersecurity. They expect organizations to have put in place measures and procedures to deal with exactly this sort of scenario. Many organizations will have been working from home already anyway, so they should have had plans in place. So think about whether or not you've chosen the right tools, you've got the right training, and you're sharing data in the right fashion. Businesses should, for this remote working time, conduct what's called a privacy impact assessment, a PIA. A privacy impact assessment is a document, there's some guidance on this on the ICO's website. Privacy impact assessment is a document which helps you to show your reasoning, a bit like a maths exam at school. It shows you how you get to your final answer. In this case, the answer is the choice you've made around which technology platforms to use to share data. It can be really helpful in making sure that your decision is rational. And as long as your decision is rational, it will help if that decision is called into question later. Of course, if you follow through the process and you make an irrational decision, it's probably not going to help, but hopefully that's not going to happen. Still on the topic of data, I think it's worth just remembering this old adage that where you're dealing with online services that are free, the price you pay is often your data. Again, most of this is set out in the small print that businesses can read and relatively straightforward to understand. But in the context of what we're talking about today, the main thing to focus on really is your trust and your relationship and the reputation that you're building with your consumers. So to take a simple example, a consumer visits a website and signs up to a newsletter. You can pretty much take it for granted that they're consenting to receive your newsletter. But what that doesn't mean is that they're consenting for you to pass their email and other contact details perhaps onto a third-party email marketing company, and that third-party email marketing company is then going to send them emails. What an organization needs to do in that circumstance is check the terms of the third-party email marketing company and make sure that their communications to the end user reflect what that email marketing company is going to do with the data. If, for example, you're an organization who's made blanket sweeping statements that you're not going to share data with a third party, or you're not going to share data outside the European Economic Area, if you then go on to use one of these online platforms or one of the email marketing companies, particularly the ones overseas, then those statements are no longer correct. You are sharing data. You're sharing data with the third-party platforms, and they are storing that data outside the EEA. So your whole data journey needs to be revisited. The reason this is so important at the moment is partly, as I say, because businesses are engaging more in a direct-to-consumer way than ever before, and consumers seem to be appreciating that. The statistics seem to suggest that consumers like buying directly from businesses rather than from the intermediary, and that's something that we're expecting to see really change. But at a time when businesses are getting more and more consumer data, they've got those vulnerabilities that I spoke about earlier. And where it really hurts a business is on their reputation. If you look at some of the large organizations that have been victims of cyber attacks or have otherwise misused data, there's very often a short-term drop in their share price, but it is exactly that, it's a short-term drop. they soon bounce back usually. Where the longer term damage comes is to their reputation. And I won't do it now, but if you were to mention some of the big brands who've had data breaches in the last few years, almost without doubt, one of the first things that comes into people's heads is the fact they've got a data breach. Can they be trusted? Are they safe with the data? So up until that point, we've looked at a couple of themes. We've spoken about the platforms, third-party platforms, and how to make some informed decisions about those. And we looked at a second theme, which is about your data usage, your data storage, and the decisions you make about how you're going to communicate lawfully with consumers. Those trends, if you like, both relate to the back office stuff. And in a moment, we'll move on and look at another trend, which is thinking more about the public-facing offer to consumers.
Ben, that seems like a good moment to pause in that case, because I do have a couple of questions that relate to the points that you've made so far, if that's okay. You're talking about businesses needing to look at the small print for suppliers. So could you perhaps go into a little bit more detail about what specifically they should be looking at? Are there key provisions, for example, that we must always check in that kind of circumstance?
Sure. Yeah, good question. I think that there are three main things. I think one of them is to do with intellectual property. So reading the intellectual property provisions would be really important, and understanding the nature of the license that you're giving. So some platforms will say that you give the platform a license to use your intellectual property to the extent the platform needs to in order to provide you with the services. And you may think that's fair enough, but some platforms go much further and they say that you're giving a license to all other users to use that content for any purpose. So it's checking that, seeing how the IP is going to be used, making sure your own house is in order from your IP protection and ownership before you share, and that you're comfortable with it. The second thing is about data protection, checking where they're going to share the data, where they're going to store the data. If it's outside the European Economic Area, if it is going to be shared with third parties, then those are things that I'd really want to think about before sharing the data. And the third thing is confidentiality. So lots of organizations will have themselves under non-disclosure agreements. Lots of organizations will be concerned about confidentiality because they don't want to undermine their own offering. For example, a service provider might treat their materials as confidential. Somebody that's making a patent application might consider their invention confidential. If you're sharing with these platforms, you may well find yourself in breach of an NDA or scuppering your ability to obtain IP registrations later. So having a look at what they say about confidentiality. For example, Dropbox on their current terms and conditions say that Dropbox can review the content that you upload, and therefore that would put you in breach of a non-disclosure agreement if the information that you're uploading is covered by one. So it's thinking through those relatively simple things.
Yeah, that's really interesting. I definitely learned something from that, so thank you. I just have another question before we move on. So many of the ways that a business presents itself to the outside world are dictated through their website and the way they market their business. So from your perspective, do you have any tips for dealing with that side of things?
So I think a lot of all of this comes back to reputation. So understanding that the consumer dynamic to the business is very different. This direct line of communication with the provider, and that also that's something that consumers seem to be appreciating. I think that's going to continue to change. So brands will possibly have more control over their own voice and their own identity than they did before when they cut out the middle person. But understanding that consumers really care about how organizations use their data. They really care about how services are delivered. So I was having a conversation with somebody recently about online reputation, and that's something that will link into the next phase. So online reputation and management of online reputation, but even little things, well, seemingly little things like your choice of who's going to deliver product. If you're an e-commerce retailer, your choice of delivery partner is really important, because the contract will be key as to obviously what you can expect from them and what the liabilities are and all the rest of it. But also from your consumer's point of view and a reputational point of view, if a product arrives damaged, they're not going to go onto the social media forums and complain about the courier company. They're going to complain about the company they bought it from. So the company has so much more control over their reputation at the moment. but there's a risk that they rush through some of these things where it can have a negative impact on reputation, or they choose suppliers based on cost and all these sorts of things. So I think a shift of view where you're not thinking about doing all of this stuff because you're worried about getting fined, or you're worried about compliance, or you're worried about trading standards asking you questions, but doing it for those reasons, doing it because you want to be compliant, but doing it foremost because it has a long-term impact on your reputation.
Yeah, thank you, Ben. That's really useful. Before we move back to your slides, I'd just like to remind everyone to please post questions for Ben using the Q&A function. We've got some good questions coming in, and we'll be getting to those in just under 10 minutes. So Ben, back to you.
Okay, great. Thank you very much. So I would like just to pick up on a couple more of those points on the outward-facing reputational side. So the first thing I'd like to pick back up on is having a plan in place to deal with reputational issues. So once you are dealing in this direct-to-consumer model, and once you're dealing online, you'll find that consumers are perhaps a bit more vocal about brands than they would be in a traditional environment, or certainly in an environment where you're not dealing directly with the consumers. So have a plan in place is really important, and that plan should combine both PR aspects and legal aspects so that you're controlling your brand. Consumers will be very quick to raise issues and complaints on social media, and those can fester if they're not dealt with, both the complaints and sometimes the comment. So having a plan in place to deal with that now is really important, especially at a time when we're seeing perhaps a reduction in patience with consumers for businesses at the moment. As we said in the introduction, early on, consumers were a little bit more patient, I think, with businesses, and understanding that turnaround times were going to be slower and so on. And that's starting to shift now, with consumers expecting businesses to be on top of all of this. So have a plan in place. Make sure that you're looking at social media and you're monitoring what people are saying about your brand. Try and take ownership of that conversation. Make sure that you've got trademarks registered. Trademark registrations become even more important in an online environment. Trademark registrations give you the ability to stop other people from using an identical or similar mark for relevant goods or services. So making sure that you have your protection in place so that you can use that as a tool if people start uploading content to marketplaces and social media platforms, or indeed trying to compete with you on search engines for AdWord campaigns. Those things can be really, really important. Think also about how you present your brand. So an issue here that a lot of businesses fall foul of when they switch to a digital model is compliance with the Advertising Standards Authority codes of conduct. Many people are familiar with the Advertising Standards Authority, the ASA, as the organization that polices inappropriate billboard ads, or goes after major retailers when they have a misleading TV campaign. But the ASA's remit also covers all online statements that are marketing, and the ASA's remit there is quite broad. They consider statements on websites and social media accounts to be marketing content. So businesses just need to be aware that whatever they say online, the old sort of adage that it's a permanent medium, it's traceable, it's always there, but whatever they're saying online also needs to comply with these codes of conduct, and that includes the content on their website where they're describing products, and it includes things that they're saying on social media to advertise their products. A couple of classic examples would be an organization that says, visit us, we're the best, whatever it is in their market, we're the best in the UK. If they can't prove that, then that statement could cause them to come unstuck. So if businesses are making statements which are capable of being proven, they should have the evidence to hand to prove it in case somebody asks questions. And when they're on social media, another thing that businesses fall foul of on this is that they have to make it clear if they're making a marketing statement that it is a marketing statement. So the classic would be the owner of a pub going onto social media account saying, I've just had a steak in the whatever the name of the pub is, it's a brilliant place, go there, but not making it clear from their social media account that they're the owner of the place. That again is an offence because it's misleading consumers. So being very aware that the statements you make have to be honest, they have to be open, they have to be transparent, and if they're capable of being proven, you have to have the evidence to back that up. And that leads nicely to the next theme, which is about consumer rights. And trading online is very different to trading offline. And one of the reasons it's so different is because consumers have much bigger rights, including a right to return. And this comes from the idea that consumers might buy things online that they might not buy offline, that it's easier perhaps to part with money on by clicking the mouse on a website than it is by handing over cold hard cash. And part of this means that consumers have quite harsh rights to refund, harsh at least if you're from the business's point of view. Businesses can control this. They have some obligations in terms of the information they have to provide about returns, about delivery, about price, about stock control, about descriptions of product and all of those sorts of things. Crucially, obligations about their terms and conditions to communicate all of that stuff to consumers. Businesses that comply with that legislation can reduce the returns period down to 2 weeks. Businesses that don't could end up with a pretty horrendous 54-week return period. And the tragedy there is that you're seeing businesses that are either increasing their online sales or jumping into online sales for the first time, completely unaware of this. They're increasing their sales to deal with a short-term cash flow but in doing so, potentially creating a long-term cash flow with that 54-week period. So making sure all of those terms and conditions are up to date. I'm talking about things like the Consumer Rights Act, if people want to look that up. Really important to do. And it's not complicated. It's about making sure that you've got your transparent terms. And many businesses want to do that anyway because they want to make the consumer journey as frictionless as possible. So certainly something that I would advocate businesses have a look at. And then the final tip, and I know that I really do sound like a lawyer when I say this, is that with increased opportunity comes increased risk. So embrace the opportunity, but do so with a plan. A couple of things that we've seen catch people out recently on this, again, thinking particularly about online trading. One of those things is that when you trade online, you are increasing your audience. You're increasing your audience geographically. So you could find yourself selling product or services into territories that you haven't sold into before. If you do that, you could quite easily find yourself caught by the legislation of those territories. The way your website is set up can have an impact here. So if, for example, your site allows people to purchase goods and it shows those goods in their local currency, or you have a delivery policy which details the countries you ship to, that might increase the risks that you're caught by the legislation of those other territories. So have a think about the opportunity and the size of the opportunity and whether the risk of being caught by legislation in those territories is worth that. Think also again about brand. So there were quite a few cases where organizations have been trading for quite some time quite comfortably under a brand in a particular location. But they move to another location and they discover that, and I'm sure people have all seen these stories in the media, perhaps their brand has a negative connotation when it's translated into a local language. That can be a disaster from a marketing point of view, but it can also be a disaster from a legal point of view. If, for example, you've chosen a brand which, whilst it was fine when you were trading in Exeter or Devon or the UK, is registered in the US or Australia or wherever it might be as a trademark, that can very often be game over for businesses because the consequences of infringing a trademark can be really, really quite severe. So just be aware of those opportunities, balancing them with those risks and thinking about the steps that you can take to mitigate those risks. So for example, with the trademark point, it's a case of going onto the registers for the various countries that you're shipping to and conducting a search for the trademark to see whether it's clear. So again, not complicated stuff. A lot of it businesses can do themselves, but worth thinking about early. So by way of wrap up, by way of summary before coming to questions, the obligations on businesses haven't really changed. You've always had data protection obligations. You've always had consumer rights. You've always had privacy concerns. You've always had to check the terms of contracts that you enter into. What is changing is the speed at which people are making decisions and this shift of businesses that were making decisions because they wanted to survive in the short term, who are now realizing actually that could be a positive impact in the long term and could change their business models. So taking a step back and picking those apart would be really useful. We're seeing that businesses' legal positions are being tested by the current situation. Terms and conditions are being pulled out of drawers and being dusted off. And businesses are starting now to look back and do that planning. That planning is really essential if you're going to both stay compliant, but more importantly, use this as an opportunity to position yourselves in the market and develop your reputation with consumers.
Ben, thank you so much. You've shared so much information and you've given everyone a lot to think about. We've had some great questions that have come in. Some are very specific and some are more general. So I'm going to start with a couple of specific questions for you. Can you highlight which of the Microsoft products have potentially concerning IP terms and conditions? And do you maybe have any suggestions of tools that don't have such problematic IP terms? That's a very specific question, but I think one that a lot of people will be thinking about.
Yes, so there is a LinkedIn video I posted last week on Microsoft Teams. So people might want to have a look at that. That's got some content in it, and there's an article on it as well. The Microsoft terms are different depending on whether you're using paid services or free services, and they're also slightly subtly different from all the different platforms. They also have this sort of myriad breadcrumb trail of terms to follow. So you start off reading one document, which is the term specific for the content that you think you're using, and it links to something else and links to something else. Most of the online platforms link to something called the Microsoft terms of use, I think terms of use or terms of service. Sorry, but it is in that article that I mentioned. That's what you're looking for. So if you're on the platform, Microsoft platform, click on the terms of use. That tends to be quite short, but it will link to these terms of services. Click on the hyperlink through to that and scroll down to the IP provision. And that's where it talks about whether or not those platforms are covered. So there are so many different platforms. Many of them are covered by the same sets of terms. But if you follow that trail, you should be able to see whether or not you're using something suitable. On the point of which platforms are suitable, I find that that's always a very good question, but a really tricky one. I think the best way to think of all of these platforms is as if they're a tool. They're there to help you achieve a goal, and it's about choosing the right tool for the job. So Microsoft Teams is a great tool. We use Microsoft Teams, but we don't necessarily share confidential client information over it. We use Zoom and WhatsApp to communicate internally, but we wouldn't mention client names or anything that was confidential in that. So I think mapping out what you want to use the tools for, checking it against those terms and conditions, and as I said earlier, the terms and conditions are usually written in plain English. It might be might take a strong cup of coffee to get to the end, but it should be navigable. And then make sure you apply it to your specific situation.
Okay, that's great. Thank you. So you mentioned our geographical reach within our businesses and how that might be different. We've actually had a question about an international perspective on all of this. So how does working with international partners outside of the EEA impact on data compliance statements? And that's specifically in respect of sharing platforms like Teams and SharePoint.
Sure. Okay. So yeah, good question. So if I just rewind a little bit, the issue here is that we're talking about consumer data, and if you as a business imagine this principle that the data belongs to the consumer, it might sit on your servers, it might sit in your filing cabinet, but it doesn't belong to you. It's your data subject's data. It's not how it's worded in the legislation, but it's a good mindset to be in. It's almost like they've lent you 10 quid. They've given it to you for a purpose, and you're going to give it back to them at the end of it. Not stepping outside the scope of the permission they've given you to use the data is really key. And one of the governing principles from the legislation is that countries should have strict legislation in place to look after data before we share data with organizations in that country. That's a bit of a roundabout way of saying it. I hope it makes sense. So if you're based in the European Economic Area, you're bound to comply by the GDPR legislation. If you're based in the US or Australia or outside the EEA, you're not. And I'm not picking on those countries in particular, just generally outside the EEA. If you're not in the EEA, your data doesn't have the same protections that it would normally have. And many of the organizations, particularly those with the online platforms, are based in the US. The legislation in the US is complete counterpoint to the legislation in the EU in terms of data security. Very much the attitude in the US is much more about, if you've got some data, let's try and make some money out of it. How can we use it commercially? Again, that's a simplification, but it's coming at things from a very different angle. So what you find is that you have a US platform that's governed by US law dealing with data that's supposed to be protected under EU law, and the data citizen loses those rights in effect when it goes to a provider who's not going to comply with the GDPR piece. There's a couple of things about that. The businesses are supposed to vet the people that they pass the data to, and that's partly the privacy impact assessment that I mentioned. But it's also about going back to that principle I mentioned a moment ago, which the data is the consumers. So if you're going to share it with a company in the States, do you have the consumer's permission to do that? Are they prepared to take the risk that their data might go outside of territory and not have the protections that are offered to them as an EU citizen or a UK citizen under the GDPR? It's not your decision to make, I suppose. And another analogy I often use is, if a friend lends you their car keys and you say you're going to drive from Exeter to Bristol, and then when you get it back, you've been to Edinburgh and back, they're probably going to be a bit annoyed. It's exactly the same with the data. They've given it to you for a specific purpose. That specific purpose is to sell them a product, or it's maybe to send them an email. It's not necessarily to give it to an email marketing company in the States who are going to sell that data on, or send them marketing that they think is going to be relevant.
Great, thank you. We've just got a few minutes left now, and I've got 2 more questions that I would really love to put to you, Ben, but I'm going to ask you for short-ish answers, if that's possible. So I'm going to combine 2 of the questions that we've been asked into one, because these are connected. So we've been asked if you could explain a little bit more about the Consumer Rights Act. I think people are concerned about the concept of bringing returns down to 14 days rather than having this at 54 weeks.
Yes.
And connected to that is, how you go about putting together a high-level plan for changing terms and conditions for current and future customers. So if you could give a brief-ish response to that, I'd be grateful.
Okay, so Consumer Rights Act, a lot of it's about transparency. So it's about not having hidden charges. It's about having a clear returns and delivery policy. It's about putting a cancellation form together that's sent out with customers. So the businesses that really get caught out are the ones that don't communicate what a consumer's rights are. So Consumer Rights Act is a fairly chunky piece of legislation. Understanding what those consumer rights are, how they apply in your particular situation, and communicating that is the only way that businesses can really comply with that. So there is some work to do for businesses to understand that. As soon as they are not detailing rights, or they are ignorant of the consumer's position, that's where the potential negative consequences come in. And they're afraid there's no shortcuts on that. In terms of putting a plan together and changing terms and conditions, if businesses have got existing terms and conditions, they can have a look at their variation clauses, and it may be that their variation clauses allow unilateral variations. If not, it's a case of putting new, putting new terms and conditions up and using those for ongoing transactions. What businesses mustn't do is try and unilaterally change the terms and conditions for goods or services that have been purchased previously. And that's something that was in the news today about holiday booking companies and so on, trying to get out of obligations there, and investigations are going to follow from there. So businesses that try and retrospectively change their terms and conditions for existing orders to try and deal with this situation could very easily come unstuck. Businesses that have existing terms and conditions can look at their variation provisions and see whether there's anything that helps them to vary there. Otherwise, they're in the same position as if they didn't have any, which is simply drawing a line in the sand, applying new terms and conditions from whatever day they go forward, and having 2 sets in effect, one for historic and one for things going forward.
Great, thank you. So last question. I think our listeners are appreciating your expertise and the way that you're describing the various points you're talking about. What would be your 1 or 2 top tips for people to focus on in the immediate future, so the next couple of weeks, as they do operate their businesses online?
I would have a look at the Information Commissioner's Office website, and they've got some guidance there on organisations' interaction with data. I think that's really important because consumers care about data, and increasingly are making purchasing decisions based on how organisations will treat data, and it goes to the heart of reputation. The other thing I would think about is how your reputation is going to be controlled online. So you're always going to get disgruntled customers, particularly at a time when your own systems are perhaps being stress tested. So having something in place so that you know what you're going to do if something happens on social media that you're not happy about, that you can control the brand, so taking trademark registrations and those sorts of things. And everything else sort of falls into place, because all of the things we've been talking about ultimately are building towards this position where the organization can look its consumer in the eye and know that it's doing right by them, and building that trust.
Great. Ben, thank you so much. You have shared a huge amount of value today, lots of things for everyone to think about. And I think those who've been watching the chat will have seen Dan's comments. So Dan Pritchard has commented that across all the topics we've covered in this series, one of the things that's coming across from all of our experts is that having a plan is essential. So that's definitely something to think about, and reflect on all of our topics and make sure that we have the right plans in place. So thanks for that comment, Dan. Anyone who wants to prolong our discussion today, you can head over to our LinkedIn group and join the group for participants of the webinar series. That's for anyone who wants to share further ideas on this and all of our topics, and of course connect in with others. So we are nearly at the end of today's session. And you should see a slide on your screen shortly, which will give details of next week's session. So, first of all, we have Ben's details. There we go. There's the details of the LinkedIn group. And now we have details of next week's session. So this is going to take place on Thursday, not Friday. Friday's a bank holiday, whatever that looks like in lockdown land. But please join us then. And Alison Lambert from Commissioning HR is going to be sharing her knowledge and insights into the complex HR considerations that we are all currently facing. Definitely a session not to be missed. You'll find links on how to book that on emails that are going to follow today's webinar, so please do look out for that and join us next Thursday. So that just leaves me to thank everybody for joining us today. We will look forward to seeing you next week. Good luck till then, and stay well, everybody. Have a good day. Thank you.